All right. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation. We are here to provide you information today about expungement of adult criminal records. My name is Nia Murray. I am Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the month of service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today is Ms. Myra Hippolyte. Also, our presenting partner today with the Houston Volunteer Lawyers, we have Ms. Ann Chandler here, and as well as the Houston Bar Association. And on behalf of them is our presenter with the University of Houston Law Center, Ms. Gracia Henderson, or Gracia.
Gracie's fine.
Gracie Hendrickson.
Yes, Hendrickson, yes.
Hendrickson. She did such a wonderful presentation.
Thank
Last
you.
week, we had to have her back again this week. That's how good she was. So,
My pleasure.
In addition to that, we also have included in the partnership the Lone Star Legal Aid, the Earl Carl Institute, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And a month of service basically is a collaboration of these 8 different organizations that come together on a monthly basis and offer a variety of different workshops, resources, information to the Houston and Harris County community relative to asset building, asset protection, maintaining of generational wealth, and community empowerment. And included in that community empowerment is a variety of different legal type workshops that we know a lot of community members need information about, that do not know where to go to have their questions answered, to get those resources and to know what's available. So here we are to provide you guys with that information. We started this collaboration several years ago, and of course we've had to adjust due to COVID and become virtual. Eventually we'll probably end up back out in the community again, but we're kind of working through all those details. But for right now, this platform has allowed us to reach people all over Harris County, other surrounding counties throughout the state of Texas, as well as all over the country, since we do broadcast on Facebook Live, as well as record this session for everyone to go back to review or to share with others. With that being said, we ask that you guys to be as interactive as you'd like to be. Please feel free to ask whatever questions that you'd like. Type your question into the chat or raise your hand and ask your question aloud directly to the presenter to have that particular issue addressed. However, we asked you to be mindful that we are recording and we are recording live. So we want to try to protect your privacy as much as possible. So please don't divulge any detailed specific information, to try to keep your questions to be as general as you possibly can. In addition to that, we want to give the disclaimer that the information that is presented here today is for educational purposes only. It is not to be considered legal advice. However, if you do find yourself in need, we do encourage you to reach out to our legal service partners that are part of the collaboration for any civil legal assistance that you all may need. So with that being said, thank you guys again for joining us. I have more information about other upcoming presentations that we have later on in the month. We want to go ahead and introduce our partners and our presenter, and we will move right on into the presentation. So Ms. Myra, would you like to go ahead?
Thank you, Ms. Nia. Welcome, everyone. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods Community Outreach Department Division. Sorry about that, under the direction of Division Manager Paul Green. On behalf of Mayor Sylvester Turner and Director Takasha Francis, we want to welcome you to the month of service partnership. Today, guys, I am at the HCC job fair. So if you are out and about, we just finished up, but we are looking for we have 2 positions open with the City of Houston Department of Neighborhoods. That's the Code Enforcement Officer Training and Community Service Inspector. If you're interested in any of those positions, make sure you go to the City of Houston website and apply. Both positions close by February 23rd. Guys, the month of service is all about that. What I just did, talk to you about job openings. We also educate the community about different issues that you have, different sources, concerns that you have. Because you know what, when we're going through different stressors in our life, we want to make sure we have all the answers, all the answers to the questions that we have in front of us. So guys, just know that you have a team of partners to let you know that you're not by yourself. Thank you, everyone. Have a great day and stay safe.
Okay, Ann, why don't we have you introduce first, and then we'll have Gracie, and then she can move right on into the presentation.
Sure. Nice to meet you all. I'm Ann Chandler, and I'm the Executive Director of Houston Volunteer Lawyers. And it's my honor to introduce Gracie Hendrickson, who is a practitioner as well as a professor, helping with the Juvenile and Children's Academy Project of Texas. And she comes with us with a wealth of information and advice about how individuals who've interacted with the criminal justice system and the juvenile justice system can take measures to get back on their feet and get, in certain circumstances, records sealed and expunged. So I'm just so glad that she's sharing our time with me today. And please do drop your questions if things come along in the chat, knowing that this is live streamed and recorded. So keep them very general. And then my role is I might be sending you back messages, and then we can get some of these ideas or questions posed to Gracie again at the end of the session. So this is too long of an introduction to you, Gracie. Thank you for being here.
Mm-hmm.
Thank you, and thank you for that introduction. Thank you so much, ladies. Thank you for hosting this event and putting it together. So with that, I'll go ahead and share my screen. Okay, do advance.
Okay, and while you're doing that, for those folks that are joining us on Facebook Live, please feel free to type your question into the comment section, and I'll be sure to read it aloud at the end as well.
Okay, so hi everyone, good afternoon. My name is Grecia Cepeda Hendrickson. I go by Gracie. And as Ann mentioned, I am an adjunct professor at UH Law, and I'm also the supervising attorney for the Juvenile Record Sealing Clinic in the Juvenile and Children's Advocacy Project, or JCAP for short. So last week I presented on the topic of juvenile record sealings, and today I will be presenting on expunction of criminal records for adults. Both of these topics are very important, so I encourage you to watch the video from last week if you didn't get a chance to join us for that one. It's on the HBA Amos Facebook page. And again, thank you to our organizers for putting this event together, and thank you all attendees for being here, especially today on Valentine's. I know there's so many other things that you could be doing, but instead you're here learning about this and educating yourself, so thank you. Quick disclaimer again that this presentation is not legal advice. It is only for informational purposes. So if you have a specific legal issue that you are needing help with, please talk to an attorney. If it's an adult expunction, juvenile record sealing, a non-disclosure, you can certainly reach out to us at JCAP and or to the Houston Volunteer Lawyers, who also handle these records clearing procedures pro bono. So a quick note about JCAP. JCAP's projects, in addition to juvenile record sealings, are juvenile representation and school discipline representation, and we also do adult expunctions and or non-disclosures. And if we don't take these expunctions or non-disclosures, we work really closely with the Houston Volunteer Lawyers and who we partner with. And so, we'll typically refer these cases out to them, and they'll take these cases pro bono as well. And so because we have sealed so many juvenile records and also expunged adult records and had a lot of non-disclosure of records as well, we have become specialists in this area and learned best practices. And we have also learned of so many collateral consequences and how clients have been negatively impacted by having a criminal record. So again, if you're needing help with any of this, any of these records clearing procedures and expunction, juvenile record sealing. We have an adult record. Our intake form is on our website at jcaptexas.org. Okay, so what is a criminal record? So a criminal record or criminal history is publicly available information consisting of records of criminal justice involvement or juvenile delinquency involvement, including arrests, dismissed charges, deferred adjudications, convictions, and acquittals. There are so many state agencies that have this information in their systems, such as Texas DPS, the county clerk, where your arrest occurred, the district attorney's office, of course, the courts, law enforcement, and this is all publicly available information. So a lot of private companies obtain this information as well and then sell this to employers, landlords, and many other members of the public. And as we talked about last week, there are so many consequences to having a criminal record. It can create barriers in finding employment, housing, obtaining licensing or public benefits, applying to educational programs, and so many other consequences. And when, for example, employers do a background check for a job, it'll more than likely pull up any criminal record or criminal history that you may have. Okay, so who has a criminal record? This is a very common misconception that people have, that that if they were arrested and charged with something and then their case was dismissed, that they no longer have a criminal record. This is not true. Anyone who has been in contact with the criminal justice system has a criminal record. The disposition does not matter. If you weren't charged, or if your case was dismissed, if you were convicted, most certainly, you all have records. All these, offenses, these dispositions have records, and it starts with the arrest. So even if the case was dismissed and there weren't any charges that were filed, there's still information about that arrest, and then typically fingerprints are usually also taken. So if you weren't charged, there will at least be a record of the arrest and what you were taken into custody for. And this will all remain on your record until your record is either expunged or sealed. And for purposes of this presentation, I will focus mostly on expungements, but just know that sealings or non-disclosures are also an option if you are not eligible for, or could potentially be an option for you if you're not eligible for an expunction. So that would be another avenue or another record clearing procedure that you could potentially be eligible for if you don't qualify for an expunction. And I'm calling it a sealing because so the term is actually a non-disclosure, but they're known as sealings, and the adult non-disclosures, which are also known as sealings, are often confused with juvenile record sealings, which juvenile record sealing, so that is the term, those are the terms that are given for that, and that's just what it's called by statute. So I'm not sure why this is skipping ahead, sorry. So yeah, don't confuse juvenile record sealing with an adult non-disclosure that's also called a sealing, and those are for adult offenses. But again, we'll be focusing on adult expunctions. Okay, so here's a nice chart for my visual people of different types of criminal offenses and delinquent conduct. Criminal offenses refer to those offenses committed by adults. So as you can see here, and delinquent conduct instead, it's for those offenses that are committed by, or that conduct that is delinquent by juveniles. So that's what we refer to it as in, in the court system. Instead of criminal offenses, they're considered delinquent conduct, and this is for juveniles. So delinquent conduct will be charged by a petition, as you can see here. And these are generally heard in juvenile district court in the county where the offense occurred. Whereas adult criminal offenses, these, really depends on the type of offense. So the class B or A misdemeanors, these are usually going to be heard in the county criminal courts at law. And felonies will usually be in district court. And then of course there's the class C misdemeanors, which are for the most part fine only offenses, punishable by fine only. And these are going to be heard in municipal court or justice of the peace courts. Okay, so there are three main types of records clearing procedures, and I have mentioned each of these briefly. So what do I mean by clearing? Essentially, it's some degree of removal of publicly available criminal record information. So again, we have juvenile record sealings for juvenile delinquent conduct, which is committed by children generally ages between 10 to 17 years old. That's when they would, be considered children or juveniles, and they would be charged with delinquent conduct instead of a criminal offense. And that's where, if they committed an offense during that time or delinquent conduct during that time, they would more than likely be eligible for juvenile record sealing. And then the two main types of records clearing procedures for adult criminal records are expunctions, which are the gold standard, and non-disclosures, which are also known as sealings, as I mentioned earlier. Okay, and here's another nice chart of the three main types of clearing procedures. Again, you would only use the juvenile records sealing procedure for juvenile delinquency records, whether it's misdemeanors or felonies or conduct indicating need for supervision. They're placed on probation. And then, so juvenile records are discretionary, meaning juvenile record sealings are discretionary, meaning that the court can choose to grant them or not. In the time that I've been with JCAP and in the juvenile record sealing clinic, and even prior to that, when I was in law school working, in this clinic as well as a student, I have not seen a court not grant these juvenile record sealings. So for the most part, if they're eligible for juvenile record sealing, it's more likely than not that the court will grant them to be sealed. And then, so adult expunction, adult non-disclosures are also sealings. These are also discretionary, so the judge can also choose to grant them or not. Whereas expunctions, if you qualify for an expunction, we'll get into that in a bit. These are mandatory. So the court has to, if you qualify for it by statute, the court has to grant your expunction. And the way that you would go about it is that you would petition the court for an expunction. There is no such thing as an automatic expunction. So, it's not your record of your arrest or of the charge that you were, charged with, or none of that. It's not going to just go away, automatically go away. You have to petition the court for it. And then just some examples down here of that the age of the person is what determines the record sealing procedure. they could potentially use. So, we have a 16-year-old who the conduct is a misdemeanor possession of marijuana. Well, then the records clearing procedure that we would use is a juvenile record sealing, because they committed this when they were 16 years old. And then here, whereas a 20-year-old who, the same offense, they would either be eligible or they could use an expunction or a non-disclosure to get this removed. And then same thing here, a 20-year-old. So that's already an adult, so then expunction, non-disclosure. Also, note that these records clearing procedures are offense specific. So you can't ask the court, hey, court, expunge all of these 20 offenses, or, however many in one go. You have to see if you qualify for an expunction or non-disclosure, juvenile record sealing for each offense. And you would go, or your attorney, because I would not recommend that anyone try to do this themselves and petition the court themselves for this. It's just, there's so many little nuances. So your attorney would see if you qualify for, if an offense qualifies for an expunction, or maybe that one doesn't qualify for an expunction, but maybe it qualifies for non-disclosure. And you would, do a petition for that and file that with the court. And then if there's any other offenses, go through the same process, see what it qualifies for. And again, each offense would need its own petition to the court. Okay, and just some relevant terminology for this presentation, which I've already mentioned a few. But a complaint or information is a formal charge or a charging instrument that accuses a person of a crime, whether misdemeanor or felony, that's initiated by the DA, district attorney. And then there's an indictment, which is a formal charge for the formal charging instrument that accuses a person of a crime. And this is for felonies only, and it's typically initiated by a grand jury. The grand jury is a special panel of jurors convened just for the purpose of deciding whether there's probable cause to charge someone with a felony. And then a no bill refers to a situation in which a grand jury fails to bring charges against the person. So, no bill of indictment was presented. And then a dismissal occurs when charges are filed either by information or indictment, but then dropped by the DA before a judgment is entered. And this could be for any number of reasons. There was insufficient evidence. You completed a pretrial intervention program, or you were, recharged in another cause, and so this one was dismissed. Or if you completed a deferred adjudication program and, you successfully completed it, and then those charges were dismissed. So a judgment, it's a court's final determination or disposition of a criminal cause. Pretrial intervention, it's a special deal offered by the district attorney in lieu of continued prosecution. So it generally consists of a course of classes and some other requirements, the successful completion of which results in the dismissal of the charge. And then deferred adjudication is when a judgment is entered by the court that places the defendant under community supervision or probation for a period of time, successful completion of which will also result in the dismissal of the charge, and for which failure to comply with these terms may result in a conviction and even confinement. So for purposes of expunction eligibility, you definitely want your attorney to aggressively try to get for you a pretrial, or have you placed in a pretrial intervention program instead of deferred adjudication. Whereas successful completion of a pretrial intervention program, you will be eligible for expunction, to get an expunction. Deferred adjudication does not, even if you successfully complete it. You may be eligible for non-disclosure, but not for an expunction. And remember, expunction is the gold standard. That's what you want to qualify for or be eligible for, just because it's once you get that order of expunction, it's going to be a lot more comprehensive and effective in getting rid of all those records about the charge, the arrest, everything. And then a discharge is a designation that the defendant has either successfully completed the terms of his community supervision or has been otherwise released from community supervision following deferred adjudications. You were discharged from, community supervision. And then statute of limitations refers to the statutes in the Code of Criminal Procedure in Texas, setting out time periods within which an offense must be charges must be brought for each type of offense. So it's essentially the time that the state has to bring these charges against you for, whatever offense it was that they maybe arrested you for. Upon expiration of that period, charges can no longer be pursued for that offense. And if the statute of limitations runs out, they haven't brought those charges against you, then you would be eligible for an expunction. Okay, so expunction eligibility, kind of mentioned a little bit about, what would make you eligible for an expunction, but we'll go into a little bit more detail. So the governing statute here is chapter 55.01 of the Texas Code of Criminal Procedure. Talks about what offenses and dispositions are eligible for an expunction. So generally, what qualifies you for an expunction under chapter 55? So it'll be generally arrest records related to fine-only misdemeanors. Remember, we talked about those Class C misdemeanors, which would be fine-only misdemeanors. So the arrest records relating to that would qualify you for an expunction. Misdemeanors and felonies that did not result in a conviction. So that's talking about those those charges that were ultimately dismissed. And again, we talked about how you want to have those charges dismissed as a result of a pretrial intervention program rather than as a result of a deferred adjudication program, because the deferred adjudication, even though you successfully complete whatever probation period you were given, that would not you would not be eligible for an expunction, whereas the pretrial intervention program you would. And arrest records, of course, relating to acquittals. So let's say you were arrested, charged with an offense, released. I'm sorry, arrested, charged, and then you go through a trial and they find you not guilty. So if you're acquitted, you would also be eligible to have that expunged, that offense or the arrest record, charges, all that expunged. And then in situations where the statute of limitations has expired and the state hasn't charged you with anything. So let's say they were going to charge you with a misdemeanor. That's what they arrested you for. Statute of limitations generally for misdemeanors are going to be 2 years. And so if 2 years have passed and they haven't formally charged you with anything, then the statute of limitations has expired and they can't bring any action against you for that misdemeanor. So then you're eligible to have that arrest record expunged. And then also, if you are pardoned by either the governor of Texas, if it's a state offense, or by the president of the United States, if it's for a federal offense. So you would also qualify for an expunction there if you were pardoned by either the governor or the president. Or if you were arrested, charged, you were tried for the offense, you were found guilty by the lower court, by the district court, and then you appealed this, and then you were found, or this finding of guilt was overturned by the Court of Criminal Appeals or the Court of Appeals. So you were ultimately acquitted by the appeals court, the appellate court. And so in that situation, you would also qualify for an expunction. And then of course, if someone else uses, your information whenever they get in trouble or they get arrested, that would also qualify you for an expunction. So just a little bit more details on the eligibilities for expunctions. So when no charges are presented, and then other scenarios. So the arrest records are eligible for an expunction when a person is arrested, but then they're never formally charged with a crime and the applicable waiting period has expired. So for Class C misdemeanors, the waiting period is 180 days from the arrest. And then Class B and A misdemeanors would be 1 year from the arrest, and then felonies, 3 years from the arrest. And of course, we talked about acquittals also being eligible for expunction, when you're acquitted, found innocent, not guilty, and then pardons as well. So again, the person was tried and then acquitted, found not guilty, that would be eligible for an expunction. And then if the person was convicted, found guilty, and then the conviction was overturned by an appeals court, they would also qualify. And then if the person was convicted and subsequently pardoned by the governor or by the president, which just, a note on that pardons by the governor and or the president, those should always be last resort. I mean, you always want to be eligible for an expunction by some other way, instead of resorting to having to ask the governor for a pardon. I mean, these are very rarely granted in very egregious injustice type of situations, that something went wrong in the courts, or they got the wrong person, the person was convicted, or some egregious injustice type of situation. Otherwise, you're not going to get this pardon. So don't rely on those. And the way that you would go about it is that you would send a letter to the governor and then include your packet of information, obtain letters from people who know you, and that sort of thing, that you are rehabilitated, you're a contributing member of society, things like that, to kind of support your letter. But again, these are very, very rarely granted, so don't rely on those, or very rarely are they given. Okay, so another situation where charges or an offense would be eligible for expunction is for dismissed charges. They are by far the most common type of record or offenses that are eligible for expunction. So this is where the individual is charged, released, and the charging instrument is then dismissed, because either the person completed a veterans treatment court program, or they completed a pretrial intervention program, as I had mentioned earlier. And again, the charging instrument was then dismissed. So these would be eligible for expunction. Again, deferred adjudications, although if they are successfully completed, also result in a dismissal of charges. These do not qualify for expunctions. And this is because the court usually orders deferred adjudications when there's enough evidence to find a person guilty to convict you, but they defer this finding of guilt for a period of time. And in that period of time, they give you community supervision instead, or probation. And so because this situation is very different from the pretrial intervention program, where the pretrial intervention program is essentially the so it's a very, you know, unique program that the DA would see if you're best served by being placed on that. And it gives it's for, you know, first time offender type of situation. It was a minor thing, and you know, just their personality, or the person that they are, is just, you know, this is very you know, unlike what, you know, or they were caught up in a situation or what have you. And so these are very so these are great programs, the pretrial intervention, great programs, but they're only offered to very, you know, specific people. And so, but again, if you have, you know, if you have a good attorney, you know, when you're going through the criminal justice process, that you're charged with something, you're arrested, charged with something, I mean, I would hope that your attorney, you know, fights aggressively for you to get you into this type of, you know, pretrial intervention program instead of deferred adjudication. Again, the deferred adjudication, there's enough to convict the person, there's enough to find them guilty, but the judge decides, you know, hey, let's give them a chance to at least have this offense, this charge, the arrest, all those records, let's at least give them a chance to have this sealed later on, because deferred adjudications would qualify for non-disclosure. So yeah, upon successful completion, of course, and the dismissal of the charge. So, however, a quick note that Class C misdemeanors, even if they result in deferred adjudication, as long as you successfully complete the probation and the charges are dismissed, these are eligible for expunction. And why is that? So Class C misdemeanors, again, are those fine-only offenses. So they're very, you know, minor types of infractions. It would be something like a public intoxication charge, where, you know, you'll be fined a certain amount, and that's it. So even if you're placed in deferred adjudication there, for Class C misdemeanors, you as long as you successfully complete that probation, you don't break any of the terms of it, and the charges are dismissed, you would be eligible for an expunction. So again, there's just so many nuances to these, and so it's really important to have an attorney, you know, help you with petitioning the court to get it expunged, or seeing first if you're eligible, what are you eligible for, and then going through the whole process. Okay, and then we talked about also when in situations where the statute of limitations has passed, you know, you're arrested, and then there's no prosecutorial action that has been taken on the case. There's no formal complaint, information, or indictment that has been filed. And so you're eligible for this arrest to be expunged. And this applies to all levels of offenses. However, you know, misdemeanors, felonies, everything. However, note that there are some offenses that there are no there are no limitations period for. So, for example, you know, murders, capital murders, all of those. I mean, the state can bring an action against you at any time. There's no limit on how many years they have from the time that, you know, they arrested you, or from the time when it was committed, for the state to be able to bring an action against you. And that's, you know, for public policy, you know, it's just good policy for those situations. And just for your more serious offenses, that's where, they don't have a statute of limitations period. But generally, the statute of limitations, again, for misdemeanors have the limitations period of 2 years. And generally for felonies, they start at 3 years. Can be more depending on the offense again, and then some don't have a limitations period. So those would never qualify for expunction based on this. And then, so we've talked about what makes someone, or, what offenses, what charges, dispositions are eligible for an expunction. So now we'll talk about, which records or offenses, charges are not eligible for an expunction. And they are essentially records relating to an arrest that occurs pursuant to a warrant for a violation of conditions of community supervision. So you were placed on community supervision or probation, and then you violated these conditions of your probation, and there's a warrant that was issued for your arrest for this. So then that arrest will not be eligible for an expunction. And then records relating to an arrest in which the person intentionally or knowingly absconded from the jurisdiction after being released. So you were arrested, charged, released, and you then don't show up for, for your court hearing, if you have a court hearing. And so, although this sounds like it's for situations where, you think of something like a person fleeing to another country or something like that, absconded from the jurisdiction, but it can be as simple as someone not showing up to their court date, their court hearing. And so, but it does have to be intentional or knowingly. So that is kind of a high bar to be able to prove. And so just a quick story on that. I had a potential client come to me where he had filed this petition for expunction on his own, which again, I don't recommend. We have plenty of help here, and we do it for free. Again, jcaptexas.org, or you can always reach out to the Houston Volunteer Lawyers. More than happy to help you pro bono, so free of charge. So anyway, so he thought he could do this himself. So he did, and he filed the expunction petition with the court. And then, at the hearing for this expunction petition, the district attorney objected to, or opposed their record being expunged. And it was for a possession of marijuana offense. So it was a small amount, a simple possession of marijuana offense, would have easily qualified for, was eligible for an expunction. But because somehow, I'm not sure how it happened, but he did not show up to his court date that was set in the court hearing. And so the DA argued, that he shouldn't be eligible for an expunction because he absconded from the jurisdiction after being released. And so this is a type of situation that could have been, foreseen, that was foreseeable. And had he obtained the help from an attorney, the attorney would have known this, that this was potentially going to be an issue, and would have obtained, all the information necessary to show that it wasn't intentional, or that the person, that he knowingly or intentionally did this. I believe that his argument was that the potential client's argument was that he had not gotten notice of that court date. And so yeah, so now he was in a situation where, he had shown up to court, he thought he was going to have his record ordered expunged. And instead, the DA opposed to the expunction because of that he didn't show up, and he claims that it was because he had moved to another apartment, and so wherever the notice was sent to his old one, that he hadn't received it, and so we would have to an attorney would have known to obtain the information to be able to fight back on this argument from the DA. And so what he would have to do now is that he would have to essentially go through this whole process again and with an attorney and file that application, spend that money again, and have an attorney, fight back on this, that this does not apply to him, that he didn't intentionally or knowingly do it. So just please save yourself that headache and that time and that money, because filing an expunction petition, just filing it with the court, I mean, it really depends on the offense. So for misdemeanors, which you're going to go file, and Class C misdemeanors, fine only offenses, which you're going to go file an expunction petition with the municipal court or justice of the peace court, JP courts. Those are typically going to be around $100 to file. But for any other offenses, I mean, this could run, this could run anywhere from, $350 to $500, $600. It really depends on the courts. Just to file the expunction would probably be around $300, $400. But then some courts require that you also pay for the notices that they will have to send to all the agencies who may have a record of this, of the, the arrest, of the charge, of the offense. All those, DPS and just all these other agencies that, are going to have a record, are going to have to be notified, hey, this record has been ordered expunged, comply with it. So some charge you for that as well, a certain amount per agency that they have to notify. So it could get expensive really quick. Okay, and then so another type of situation where you would not be eligible for an expunction are records that are relating to a partial acquittal. So by this, this is mostly for situations where you were arrested and you were charged for, more than one offense. So, you were charged with, say, 2 offenses, and you were acquitted of one of these, but you still have a conviction, or you're still subject to prosecution for at least one other offense arising from this same criminal episode. And again, this is mostly for situations where you were arrested. So it's the one arrest, but you were charged with, 2 or more offenses. And then the Texas Penal Code defines a criminal episode as the commission of 2 or more offenses, regardless of whether the harm is directed toward or inflicted upon more than one person or item of property under the following circumstances. So the offenses are committed pursuant to the same transaction, or pursuant to 2 or more transactions that are connected or constitute a common scheme or plan, or the offenses are of the repeated commission of the same or similar offenses. So you can see where, all of this can get very confusing really quickly. And so there's just so many nuances to the statute, when you could be eligible for an expunction, when you would not, when you could be eligible for non-disclosure. So again, it's just best to seek help from an attorney, to go to an attorney for this. And again, we help you completely for free. And so again, our intake form is on our website, jcaptexas.org, or again, reach out to the Houston Volunteer Lawyers, who are also fantastic. Okay, and so non-disclosure eligibility, generally, this would be for your record sealings. which again, the gold standard is expunction. So if you're eligible for an expunction, that is what you want. It's just more comprehensive, more effective in getting rid of everything and wiping out, your record. So generally, deferred adjudications are the ones that are eligible for non-disclosures. So again, deferred adjudications are not typically eligible for expunction, but they are eligible for the most part for non-disclosure. Again, as long as you successfully completed that probation, and then the charges were dismissed. But, again, if you have a specific situation that you're needing help with, please reach out to us. We're more than happy to look into it for you and let you know what you could potentially, what you would be eligible for. And then we could help you also with moving forward with that particular record clearing procedure. Okay, so the contents of an expunction petition. So what you would have to include in the petition, those are also governed by statute. So the relevant statute is chapter 55.02 of the Texas Code of Criminal Procedure. So chapter 55.01 tells you, what types of offenses and disposition qualify for, or who are eligible for an expunction. And then the next section, 55.02 tells you more of the procedure and the contents of an expunction petition. So the petition must include or explain why such information is not included. So a petitioner's identifying information, their name, date of birth, their social security number, their ID. Some people who don't have, a Texas ID, we would just say, the petitioner does not have a Texas ID and just explain that. But it does have to be included in there, why it's not included, even though it's required by statute to include it. And then the offense charged against the petitioner, the date the offense was charged against the petitioner, and when they were alleged to have been, when the offense was alleged to have been committed, the date the petitioner was arrested, name of the agency that arrested the petitioner. So this could be the Harris County Sheriff's Office, the Houston Police Department, and just so many other agencies and in different counties that could arrest a person. So whoever that arresting agency was, you would include it. And then all the other information on there as well, including what agencies would have a record of the offense, of the the charge, of the arrest. So you would include, Texas DPS. Texas DPS is the central repository of criminal information for the state. And so you definitely want to include Texas DPS on there. So they're going to have, a copy of all this information on the arrest. And then, of course, the district attorney's office, along with, so many other agencies that could potentially have a copy of this, and, that you would need to let them know, hey, I'm filing, an expunction a petition to have my record expunged, just so that you provide notice. The statute does require that you provide them with notice. So you would do that. And so just really quickly, an expunction typically takes around 6 months to a year from the time that we petition the court to expunge your record to the time that your record is wiped from the system, or from the time the records, physical copies, any physical copies are all destroyed. So Please take care of this as soon as you're eligible for an expunction. Again, some of the eligibility criteria, some of those require, that you wait a certain waiting period, and some you're immediately eligible for them. So, for example, the pretrial diversion program, if you successfully complete that probation and then get that charge dismissed, you're automatically eligible to have to petition to have this record expunged. So please take care of it as soon as you're eligible for an expunction. And for my fellow attorneys who represent, who practice criminal law and who represent people with, these criminal offenses that have criminal charges and all that, you would, at the end of their case, you would let them know, hey, after this certain amount of time, you would be eligible to get this expunged, or you would be eligible to get this sealed. So make sure that you either come back to me, if they also take care of expunctions or non-disclosures, that you come back to me, or that you reach out to an attorney, or to JCAP, to us, or Houston Volunteer Lawyers to make sure that you're doing that. Because don't try to go to an attorney, or don't come to us the day before you're interviewing for a job, or that you're trying to get that license for your profession, or what have you. You don't come to us the day before that you're trying to, or the week before even, that you're trying to do these things, because petitioning the court to have your record expunged and then actually getting that order of expunction, so you would petition, and then you would have a hearing scheduled within 30 days that you've submitted the petition, and then you would have the order, hopefully ordering your records expunged, and then after that you still have the time that the agencies get to be able to comply with this order. So it could very easily, like I said, take 6 months to even a year. And so this is not something that can happen overnight. So please plan accordingly. And again, for my fellow attorneys, make sure that you're advising your clients of when they would be eligible, if they're eligible for an expunction or non-disclosure. Okay, so what's the effect of an expunction order versus the effect of a non-disclosure order? So again, expunction is the gold standard. An expunction, so here they are side by side. An expunction is a lot more comprehensive and effective than a non-disclosure order. So when a judge orders your records to be expunged, it eliminates the records from your criminal history, and eventually all the records relating to the arrest, the charge, the disposition should all be destroyed and deleted. And the individual has the right to deny that this incident ever occurred. And of course, there are always some exceptions. So we'll go into those in a little bit. And so, however, when a judge orders on non-disclosure, if they order your records to be sealed, agencies are prohibited from releasing record information to the public, but they still have them. And again, this is also known as a sealing of records. And it's because it's exactly that. You're basically sealing or closing off these records from the public. But law enforcement, state agencies, they still have access to these records. But the charge should stop appearing on your standard background checks, on employment or employer background checks, maybe even for housing. But there's really no there's really no guarantee, just because that they're essentially still out there. The records are still out there. It's just that the agencies are prohibited from releasing this now. You can, with your non-disclosure order, once you have it from the judge and you see that you applied for a certain job, and then your employer comes back with, hey, you know, we're actually not going to be able to hire you because you have this criminal record. And if it's, you know, if it's the offense that was ordered to be sealed, you can, you know, reach out to whoever that, you know, private background search company that the employer used, and let them know, hey, I have an order, you know, for that, you know, requires that you comply with it, and that you know, these records are supposed to be sealed. You should not be disseminating them. So you could certainly do that. And again, you have the right to deny that the incident occurred, but again, there are always exceptions, as there were exceptions with the juvenile record sealings. Okay, and so the effect of the expunction order, again, it's pretty comprehensive and really effective. So once it's granted, the clerk of the court shall send the order, sorry, to each agency listed in the order. So remember how I told you that you would list all these agencies that potentially have a, you know, copy of this record. You would list them in your petition. You would also, or your attorney would also list them in the order. Or if the court issues out the orders on, you know, on their own, and the attorney doesn't have to file the order, the proposed order, well then the court staff, you know, would include the agencies in the order that you included in the petition. So they would then, you know, after it's been granted, they would then send the order to each agency listed in the order. What I always like to do is, you know, even though the clerk does this, I still like to send out these expunction orders to all the agencies myself once I receive it, just because that gives me a peace of mind that I sent it also to all these agencies, and to ensure that it was received that way too. Sometimes the court clerks may not have the most up-to-date information, or maybe this agency allows or prefers email service of the order or of any legal documents, and so you would, you know, just send it via email and ensure that they received it that way. And they usually send back a confirmation, so that also helps me a lot. And you know, I rest assured that it was sent to that agency. And then they're also, you know, they're required to release any maintenance or dissemination or use of records subject is so the release, maintenance, dissemination, or use of these records subject to the expunction order is prohibited. There are some exceptions. The DA can retain some records under certain circumstances, and those are in the statute. The order requires all the agencies to return all records in their possession to the court, or obliterate references to the expunged charge, and delete any references to the expunged charge from their public records. And then the clerk destroys any records it receives from the agencies between 60 days, again, and up to a year after the order is granted. So you see why it can take, you know, some time. It's an involved process. And then DPS is also required to notify the FBI and other federal depositories that it may have disseminated this information to, and any other private entity that purchases the criminal record from DPS of this expunction order. So the limitation, there are so many background check companies, you know, private, many of which don't have the best record keeping practices. And so it is possible that your expunged charge and this record can remain out there. However, as I mentioned, you will have that, copy of that order. Your attorney will provide you with it. Keep it somewhere safe. This is something that you want to make sure that you have if you're in a situation where this was ordered expunged, but then it's still coming out because there's this private company who's still disseminating it or who still has it out there or what have you. So it is a Class B misdemeanor to knowingly disseminate expunged records. So if you go online and you Google yourself, or you Google, this offense that should have been expunged and that was already ordered expunged, and it's been over a year. So this already should have been complied with, and you see that there's still something up there and that there's still something that you can find, because so many things are on the internet now, including that. And again, it's public information. So yeah, you would just reach out to this company and provide them with the copy of this expunction order and say, hey, please take this down. This record was ordered expunged. Here you go. And again, once it's granted, the person may legally deny the arrest of the charge ever occurred or the fact that it was expunged. Exceptions. If you're asked under oath in a criminal proceeding, the person may state only that the matter has been expunged, so that they have, an expunged offense. And also the federal government, just like with the juvenile record sealings, even after you get this order sealing your juvenile record, you still have to disclose it to the federal government that you have this, this matter expunged, that you have an expunged matter. Now, again, they can choose to ask you more questions about it. So that's that. And then ethical proceedings as well, mostly because in ethical proceedings, they want the person to be honest, and it's a poor reflection on their character if they do have something in their past that they're not disclosing. So ethical proceedings as well. And then here's a side-by-side comparison of the effects of the expunction order and non-disclosure and what happens with these. So the distribution of the order, once it's granted, the clerk is responsible for notifying the agencies listed in the order. And again, I believe that the best practice is to not just rely on that. I like sending it out myself also to these agencies. And then the effect of the order, once they receive the copy of this order, the agencies must, one, mail any records to the courts that they have that are, physical copies, obliterate references in any remaining records, and then delete any public record references. And for non-disclosure, again, it's also called a sealing because it just stops these agencies. They must no longer, keep releasing this record information to the public, except to these permissible agencies that we talked about, like law enforcement. And so the timing, your record should be expunged between 60 days. Again, 6 months to a year is more of a realistic. And then non-disclosures, your record should be sealed within 65 days of the date of the order, just because all the agencies have to do is no longer continue disseminating this information. So it's not like an expunction where we are literally like getting, shredding documents that they may have, or mailing to the court any records that they may have of this offense, of this charge, the arrest, all of that. And then also making sure they're going through their systems and deleting everything that they may have there. And the client's rights, again, they can legally deny the incident ever occurred, with some exceptions if you're under oath in a criminal proceeding for expunctions, the federal government, and then ethical proceedings. And the non-disclosure, the exceptions are that law enforcement, state agencies still have, access to these records. And then again, the federal government and ethical proceedings. And with that, we've reached the end of the presentation. I hope I've provided you guys with a lot of useful information. Again, if you have any questions or if you're needing help with either an adult expunction or non-disclosure, juvenile record sealing, please feel free to go to our website, fill out our intake form. If you have any questions or if you want to reach out to me directly, this is my UH Law email. And then this is my firm email, and you can reach out to me, with any questions you may have to those emails as well. Thank you.
So Gracie, we got 5 questions during the presentation.
Oh,
and thank
nice.
you so
Okay.
much for this really hands-on helpful information.
Yeah.
I'm kind of not going to do it in order, but one of them you kind of addressed. You talked about how
Okay.
expunctions, great, they take along even after they happen to like get off people's site. You said up to 6 months to a year, but that there's some shady companies, where you said up to 1,000, all these private enterprises. So what would someone do who was effective getting that gold standard expunction, but still finds their mugshot on various internet websites or, by one of these companies?
Yeah, exactly. So yeah, unfortunately, this does happen. And so you would reach out to this company, if they have a little contact us, button that you can press, reach out to them, call them, email them, and make sure that you're informing them that, hey, this should no longer be public information. You shouldn't have this. This is, subject to an order of, I have an order of expunction for this. So comply with it, send them a copy.
Yeah. So it may
And they
just be
should
hard
comply with
work
it. If
and
not, they
time.
can get in criminal trouble themselves. It's a Class B misdemeanor to continue disseminating that information when there's an order of expunction.
Helpful to know. So just let that company know you're violating the law. This has been expunged. Okay. Second is, for someone who just doesn't know necessarily the status of the record, maybe they're trying to decide to reach out to an attorney or not. Does it make sense doing some preliminary research of whether they're eligible for those requirements of expunction that you went over or non-disclosure? Where do they start?
So there for offenses, committed in Harris County, there's the Harris County District Clerk's website that you can always go and, check what, if you have a criminal record, what comes up there. It's a background check there. You would have to create an account with them, but honestly, you come to us, we will be more than happy to take care of all that for you. And we'll look at all that. We'll pull up those records, whatever's on the Harris County District Clerks, or maybe in another county. And we'll get those, those records as well. So we can, then do the analysis, because it is like I said, it's a nuanced, confusing analysis that has to happen. And so, so you just don't want to make a mistake and then, like I said, try to represent yourself, go do an expunction, and then something comes up and it could have been avoided. So.
Right. So what I hear, if somebody is low income, or at least for us, it's low income, not sure about your organization, it's not so easy to figure this out. And it's completely fine to reach out to an attorney and have them help you in accessing the status of criminal stuff. Because
and we don't have an income requirement. You can just fill out our intake form on our website, jcabtexas.org, and you'll put just very basic information, your name, your contact information, and then what is it that you're needing help with. If it's not a juvenile record sealing, put that it's for an adult expunction or non-disclosure, an adult record, and we'll be more than happy to look into that for you and let you know if you're eligible, what are you eligible for, and again, we can absolutely help you with the actual process of getting it expunged for free.
And one kind of related to this, I think you went over all the requirements of what's in that legal packet. What is an attorney assembling so that they can submit your request? What about when someone is living in a county not where all this went down. So somebody has to be living in the same county of where that criminal charge is to get this paperwork resolved?
No, so you would have to file the petition for expunction or non-disclosure. You would have to file that in the county where the arrest occurred, but it's not necessary that you be living there, yourself. So yeah, no, there's no requirement for that. Just that it actually gets filed in that court of that county.
Great. And then one was kind of just like, God, an advocacy consumer right issue is when someone is kind of in the criminal justice system or the juvenile justice system, is our government informing individuals of their right to get their charges cleared up, through non-disclosure or expunction?
Oh gosh, I certainly hope that there was some sort of, information that is being given by the government. But as far as I know, I mean, it's up to, us, the attorneys, to kind of give this information to our clients when they're involved in the criminal justice system. If we're representing someone, making sure that they know that, after a certain period of time, or if they'll be eligible for what they'll be eligible for, and when they can actually start, working on that, either, going back to that attorney or coming to us. So yeah, unfortunately, I don't think that it's talked about enough, and that there's not enough, information out there, and that a lot of people don't know, about these records clearing procedures, and a lot of people don't know even that that they still have a record, even if their charge was dismissed, or even if their case was non-suited or what have you. So, you still have a record of at least of the arrest. So that needs to get taken care of. If not, it'll follow you.
I heard you talking about like 4 parts of the case here, like analysis, investigation, putting together the documents, fighting the charge, showing up at court usually. And then the 4 being post order, making sure those orders get in the right hands of the government agencies. And so there was another question here of, is there a cost to that 4 steps? So if somebody's doing this on their own and has an order, how do they know where to send that order to? Or is it too late to even ask for legal help at that point? And is it free to send out all those orders to who they need to go to?
Yeah, so it's never too late, right? Like if you have that order, that expunction order, and you're just needing help with disseminating it, or making sure that you're providing notice to these agencies that have copy of the record, you can always come to us. Like we'd be more than happy to, or to the Houston Volunteer Lawyers, we'd be more than happy to guide you as to like how you can, how to best provide notice to these agencies. We have a whole list of, agencies that we have. We have their email information, their address, if they prefer service by email, or, what are their preferred. And then for some, we have specific contacts where if there's an issue with something, we can reach out to that person. So yeah, we've done all that for you guys. So yeah, if you're having, a problem with, okay, let's say that you did actually go through the whole process and now you have this order, how do I get this order to the agencies? Yeah, absolutely. We'd be more than happy to help you with that as well. And there's generally no cost involved if they accept service by email, but some, who would prefer service by certified mail, then there's going to be, the certified mail charge, $5-ish per notice that you're sending.
Great. And just again, a reminder, if somebody is looking for legal help or legal information, you can go to the Juvenile and Children's Advocacy Project of Texas, or JCAP, or Houston Volunteer Lawyers. But also a plug, if you really just want to get legal information and trying to assess your own situation or what is the legal process, a good plug in the text that I want to highlight is the Harris County Robert Hainsworth Law Library can meet you individually, usually in person or virtually, and walk you through your situation with really helpful legal information.
And we did a workshop, one of the Amos presentations several months ago too, with the law library, and they talked about all of their services and what's available and where do they go for information and how do they get access to different forms and things. So if you search for the Amos Houston YouTube page, you should be able to find that video there as well.
Right. And today's conversation was, general about record clearing, but a real focus on expunction. And you did mention a lot on juvenile sealings and some on disclosures. If somebody wants more information on non-disclosures, maybe that could be a future topic. I'm looking at Nia Murray. But what would you Gracie, what would you recommend?
Adding to your schedule.
Yeah.
Yeah. So if anyone has, a question that's more so geared towards non-disclosures, feel free to reach out to me. I'm more than happy to look into that, for you and let you know if you're eligible for non-disclosure if it's not an expunction. Like I said, it's expunction is the gold standard, but I'd rather get something. So seal that record if you're eligible for the non-disclosure for a sealing. Absolutely.
Same with the Houston Volunteer Lawyers. We do a lot of non-disclosures. And if you think you're eligible for that, we frequently have volunteer attorneys waiting to help individuals with this important matters. And I think I cut you off, Nia.
If there's enough information to specifically just talk about disclosures, since we had to separate the juvenile sealing versus the expunctions. So if there's enough feedback from folks, if they just want to talk about disclosures, then we'll be more than happy to arrange something if there's enough information out there to get to folks. So definitely want to put it out there.
Excellent. Well, I think this might wrap it up, and we just say thank you, Gracie, and thank you to our audience. Back to Nia.
There were a couple of questions that actually got emailed to me prior to the beginning.
Okay.
If a pleaded deferred adjudication of guilt, do you have to expunge your case or record after the probation has ended?
So again, those deferred adjudications, those are not going to be eligible for expunctions, even if they successfully completed their probation period, even if their case was dismissed. And this is specifically carved out in the statute, where if a person received that and got placed in community supervision because of that, because of a pretrial intervention program, those aren't eligible for expunction, but non-disclosure, they're generally eligible. And yeah, they would have to go through that probation period and successfully completed and have the charge dismissed.
Okay, another question here. Criminal records and homelessness are connected due to infractions regarding loitering, petty theft, trespassing, and etc. As a social worker with low and no income clients, how can we assist our homeless and low income clients with receiving assistance on expungement?
Yeah, send them over to us. Yeah, refer them to JCAP or the Houston Volunteer Lawyers. Let them know that we do help and do this for free. So yeah, just feel free to send them over to us.
Okay, a couple of these folks were just kind of making comments as part of their questions. Someone told me that they had their record expunged, but later saw their mugshot. I believe Ann addressed this one already. How did it get there and what can be done about it? So yeah, I think we covered that part already. Okay, yeah. I had a question in regards to a law and housing. So if someone had a felony conviction 15, 20 years ago, and they go to apply for an application for an apartment or whatever, how far back, is there a law that limits how far back the landlord is allowed to look at their background or criminal record if it was a 20-year-old conviction?
Not to my knowledge, honestly. Those are gonna, all these convictions and the arrest record and everything, disposition of the case, everything will remain out there forever unless you actually get it expunged or sealed. So, and there's, you know, they can do an extensive background check. It really depends on what their, you know, their policies are and how extensive their searches are. But yeah, they can, you know, they are out there and they would be public information. So.
And so
So they
that's
can-
different. So in Texas, you know, we don't have protective laws for tenants in this area. So if it's a 20-year-old conviction, it's still a 20-year-old conviction unless it's been expunged. It's state by state. Some states do. So if somebody is looking in housing in another state, that the statute may be very different.
Yeah, I saw on some website or whatever a while back about there being like a 7-year limit in some states. I didn't know if Texas was one of those
Okay,
states. So,
yeah.
okay. All right. I know that that's a big issue when it comes
I
to
learned
housing,
that new
especially-
today now,
it-
that in some other states there are.
Yeah, in some other states there are.
For that.
That is a big issue, especially with the availability of housing in
Yeah.
the Houston-Harris County area. That's a really big topic. But thank y'all very much. Really,
Yeah.
really appreciate you guys getting this information. If nobody walks away with any other information, just know that these services are for free, that there is a difference between an expunction, sealing, and a disclosure, and all of these other things wrapped up in it. So do not try to be the jailhouse lawyer and figure all this stuff out by yourself. Please reach out to the professionals to get this assistance at no charge, because it's there, it's available. If you guys don't need it, please feel free to forward the information along to someone that you know of that may find this information to be beneficial. Please definitely share. I will be emailing the link for this recording for everybody to go back and review if you did have questions, as well as share. And also just keep in mind that on Amos Houston TX on Facebook, the live sessions are there as well if you'd like to go back and see that and previous ones. I will also send a link for the juvenile justice that happened last week in case somebody wants to refer back to that one as well for that information. A couple of different little websites, the law library, Texas Law Help, all of those resources and links I will put on that email for everybody to have access to those resources as well. So if there are any other questions or anything that you guys may have thought of or something in the meantime, or I'll include you guys' contact information on the email so that they can also follow up again with you as well. So with that being said, thank you very much for your assistance. Thank you for providing all this information to the community. Thanks for all of you for coming back and participating and joining us for another month of service presentation. And we hope to see you at future workshops. Let's see, what do we got coming up tomorrow? For homeowners, we have our maintaining and adding value to your home. If you, Miss Sabrina, I definitely wanted to call you out. Future homeowner, if you want that information, definitely come out and get that information about adding value and maintaining and maintenance tips to your home. And we don't have anything Saturday next week. If there are any tenants that are on the line, we have our eviction presentation as well as the property tax and foreclosure that's coming up next week. So definitely want to tune in for all of those as well. But again, thank you guys very much. You all have a wonderful remainder of your afternoon. I'm gonna make sure, what time tomorrow? 1 o'clock. 1 o'clock will be the same time. You all have a wonderful remainder of your day and take care of yourselves and stay safe.
Thank you. Thank you, ladies.
Bye-bye.
Bye.
Thanks.